it's time for, guess what, IP in the news. And today we're going to be talking about a case that Gearhart Law was involved in. And the case is called BNIC versus Cologne and Cognac. And our client held a trademark registration, including a logo for the words Cologne and Cognac.
What kind of business was Cologne and Cognac?
They were a record label,
right?
Okay. And so he has this. Our client is Trav Torch, and he's published like 3 CDs, and he's kind of got this very white groove going for him. And he named his company Cologne and Cognac. And
well, you tell me he sounds like Barry White. Ooh, I must listen to this.
He's like very deep voice.
Okay.
And so he went and he filed his own trademark registration. And after the trademark got allowed, the BNIC company or group, the group that represents all the cognac makers in France, filed to have his trademark removed from the register.
Because they thought people were going to drink CDs? It's totally different.
Or Cologne and Cognac, or they thought that somebody was going to walk into a liquor store and ask for a Cologne and Cognac record or something. Anyway, they thought that people would be confused between the actual liquor cognac and his record label. And so there are some interesting legal issues in the case, but it turned out that our client won. And now they're all upset about this because it creates a precedent for other cognac cases. And cognac is a designation mark. It means that it designates where a particular product was made or grown by a particular process. So champagne, for example, is not a trademark, but it's a designation of origin mark because champagne is grown in the region of France called Champagne. And the same thing with cognac. In order to be able to call something cognac, you have to make it by a certain process and using, certain things that can only be found in France. So that said, now they have a case on the books that says these designation marks are not famous, right? And that in a legal sense. And so now they're all upset about it, and they've hired some really Tony lawyers from Washington, D.C. to represent them. And we're expecting the group that markets champagne and the trade association there to get involved. And our client is a policeman in Newark, New Jersey, and he advertises he throws parties, and he advertises his parties by nailing flyers to telephone poles. And now he's got the whole liquor world on him because he filed a trademark.
But what's weird is that you can buy a dress, not that you would, but I would buy a dress that is the color champagne.
Right.
So they do use champagne for other things besides the actual alcoholic drink, right? So
absolutely.
So this is kind of the same thing. So I don't know.
All right.
Well, he's going up against the mighty Richard, or they're going up against the mighty Richard. So we will see.
No, I mean, I think that, in some cases it's the lawyering, but in this case, the facts are pretty straightforward, in my opinion. And that it's different kinds of goods. It travels in different channels of commerce, all of the things that make for a trademark infringement suit. And I thought this was kind of a bad hill for the Cognac Association to die on because the mark was so different and it's just too many differences. And they decided to take a shot, I guess, because they thought Trav would be an easy target. And it turned out that he won. So very happy about that. So anyway, it's time for Richard's Roundtable. And I would like to ask our guests to comment on this. And what do you think about this situation?
Well, I'll jump in just because I find it very odd. The notion that as I'm driving around listening to a CD from this company, that my first inclination would be to dab a little cognac on just in case I get pulled over by a policeman. I just am not sure where this is going.
Yeah, what's the connection here?
I know it's amazing. And but you know, conceivably this is a case, I know this sounds weird, but conceivably a case that could go to the Supreme Court, because there's another case out there in a different part of the country that decided that these marks were entitled to be termed famous in the legal sense. And therefore, if the circuit court that we're in decides differently, then it could go up to the Supreme Court, which I think is also amazing. So I probably would get really, really nervous there. I think. I mean, that would.
Would you be a little scared there?
Yeah, well, they're way up there. They've got those black robes, and they look down on you. Of course, I'd be scared.
Well, you didn't go to Catholic school like I did, where the nuns were scary and they're wearing the black robes. And you look at the Supremes, you're like, oh my gosh, it's a whole bunch of nuns ready to slap me down.
So anyway, Sergey and Vadim, what are your thoughts?
Well, I'm actually curious, Richard, how these organizations choose who they go after, because I can tell you, we were born in the former Soviet Union. Cognac is a very popular beverage there, and I don't think anybody's enforcing any trademarks there because it's called Cognac. I'm very certain it's not actually sourced from France. And so I'm just curious how they choose who to go after, because I'm sure these infringements happen in a more direct way in other places.
That's really helpful for our case. Would you be willing to sign a declaration?
No, I'm not going against the Russian government here.
No, that's interesting. And I think you're right there. To the extent it's enforced outside the U.S. is a very interesting question. And I don't really know the answer to that, but I suspect that there's a lot of off-label cognac being sold, probably even in the United States, right? And,
certainly. And I've had it.
Yeah.
And it seems like there's a litmus test that inevitably comes down to whether or not it's worth prosecuting, whether or not it's worth chasing an individual or a small group whose impact is minimal. While obligated to protect your mark, do you really want to go after every single little guy? I've been knocked off so many times in so many countries in so many places. You have to pick and choose, I guess.
Right. It's like almost a game of whack-a-mole. But why they chose this is our particular client is, if he were making cognac, I would get that, but he wasn't. He was singing like Barry White. So, what's with that?
So did we hear from Sergey? I'm sorry, I did not introduce you guys properly with me. So we heard from Sergey. So Vadim, do you have thoughts on this?
Yeah, I do. Thank you. And by the way, y'all pronounced our names perfectly from the first try. So kudos. Oh. I tend to agree with what's being said about the fact that it's a different product category, and that's going to make it a very difficult case. Actually, Sergey and I have had experience with other companies advertising using our name, but it was another education company. And so in this case, we would report the ad and it would get taken down very quickly. So there's not much wiggle room in that type of scenario. But here, where it's a different product category, that the record doesn't come from that part of France, right? So it's not even a point of confusion.
Right. Like we're all going, what's the connection here? Right?
Yeah, it's like Delta Dental and Delta Airlines. Nobody gets those two marks confused. They know one is a dental company and the other one is an airline. So
and they're both the source of pain.